Minister Nandlall, earlier today, Mr. Peters asked, filed a motion, however it was placed, for the judge to recuse himself from this particular case. You objected. Could you state your rationale for objecting to such a motion?
Mr. Peters shocked me by rising at the beginning of the hearing of today's proceedings to make an application for the judge to recuse himself. He stated the grounds to be that the judge is biased towards him as a result of a previous incident and that the judge would not give his client a fair trial. Apparently, there was some COI some years ago that Mr. Peters and the judge had some difference of opinion in respect of. My clients are unaware of that. I am unaware of that. The law in relation to a judge recusing himself and in relation to bias is very clear. First of all, it's a very serious matter. If you ask a judge to recuse him or herself, or you accuse a judge of bias, you have to have substantial ground to support your application or request. You have to show that the judge has some personal interest in the matter, financial or otherwise. Obviously, there was nothing like that being alleged. So I considered the application by Mr. Peters as without basis and completely misplaced. And I invited the judge to let's proceed with the case. You see, any person can stand up if they feel that the case is not going their way and make an application for the judge to recuse him or herself. That would amount to forum shopping. It means that you're choosing your own judge. And if for some reason you don't like this judge, then you want a judge that you like to try your case. It doesn't operate like that. Granted, of course, that every tribunal trying a case must be impartial. But if you want to question the impartiality of the tribunal, then you have to do so on sound basis and on reasons recognized by the law. So I don't think that those reasons presented themselves here, and I oppose the application. The application by Mr. Peters was overruled, and the judge proceeded to hear the case.
Sir, if you will, sir, could you just give us a brief synopsis of your line of questioning? I know you focus a lot on the standing order. What is the normal practice in the conduct of the sitting of a National Assembly, and what actually transpired in December 2021? Also, the list that came up with the speakers.
Well, if we are to go back a little, the case started a few occasions ago where Comrade Ramjatan was the first witness, and Comrade Ramjatan explained, one, what happened the day. He confirmed the raucous, riotous, vulgar behavior took place. He explained who committed or behaved that way. He confirmed that the mace was broken and taken from its place by the members of the opposition. He confirmed that members of parliament, rather staff of the parliament and members of the opposition were dragging and pulling at the mace, that the mace broke, that one member of staff was dragged along the tile floor, etc. Amjatan confirmed all of that. And he said who and who were part of that. Then Norris Witter came yesterday, and I asked Witter whether, well, first of all, Mr. Witter affidavit were about 45 pages. We got about 20 or more of those pages struck out for inadmissible evidence. Mr. Jones's affidavit was some 96 paragraphs in length. We got about 35 of those paragraphs struck out on the basis that it contained opinionated evidence which are inadmissible. It contained hearsay evidence which is inadmissible, and or it simply drew conclusions rather than assert facts or allege facts. Affidavits must not draw conclusions. Conclusions are for the court to draw. In consequence, the court struck out 35 paragraphs of Mr. Jones's affidavit. So Jones began to testify today, and you all heard the testimony. He confirmed that the Speaker is in charge of the National Assembly under the standing orders. He confirmed that the Speaker is responsible for maintaining order in the Assembly. He confirmed that the Speaker's ruling must be obeyed by members of Parliament. He then agreed with me that the Speaker rejected his application for the matter to be taken to the Select Committee, the bill to be taken to the Select Committee. He agreed that in spite of the Speaker's ruling that the bill will be debated, he proceeded to stand in his seat for several minutes, debating the Speaker's ruling. He agreed with me that all the members of the opposition stood in defiance of the Speaker's ruling, in their seats, thumping the desks, shouting, chanting loudly, all of it in defiance of the Speaker's ruling. He said that he couldn't recall. He first said no. He said that he recalled the Speaker citing about 8 parliamentarians for their misconduct. Then he agreed with me that they descended into the rotunda of the Assembly without the Speaker's permission. He agreed with me that they marched in circles, chanting, singing, shouting, and blowing whistles. He said that they did that for several minutes. He said that as Dr. Ashley Singh continued to speak, they then approached him, Dr. Singh, and gathered very close to him. He agreed that during that period of time, the Speaker kept telling them to take their seats, and they ignored. He also agreed that the government members, because the opposition were getting very close to Dr. Singh and were surrounding him, that the government members then came and barricaded Dr. Singh as he was speaking. He then agreed that some members of the opposition then grabbed the mace and hauled it away from its place. He then agreed that members of staff of the National Assembly and the opposition members began pulling and tugging at the mace. He agreed that that commotion continued out of the House, but he claimed that he didn't see what happened. He confirmed that he volunteered the names of a few opposition members who grabbed at the mace, and I believe he mentioned Annette Ferguson and some other person. He agreed that when the mace was returned, that it was broken, or he said he heard the Speaker said it was broken. He said that he couldn't doubt the Speaker's statement that the mace was broken. He then agreed that another instrument had to have been used instead of the mace. He also agreed that all of his members were out of their seats by the time Ashley Singh concluded his presentation. He agreed that the standing order says that a member must be in his seat at the time and then be invited to speak by the Speaker, and that none of his members were in their seat at the time Dr. Singh concluded. He earlier said that he as Chief Whip, Gail Teixeira as Chief Whip for the government, prepared a speaking list, which the two of them signed in triplicate, that one copy he kept, and one copy Gail Teixeira kept, and one copy, he said, according to him, was given to the Speaker. I asked him whether he gave any copy to the Speaker. He said no. I then showed him a list of speakers that he tendered into evidence, which list he said was the agreed list by him and Gail Teixeira. And I showed him a copy of the list that he tendered in evidence, and I asked him to point out, first of all, his signature and the signature of Gil Teixeira on that document. He couldn't because the document has no signature. So he had to agree with me that that was not the list, if there was a list, that was not the list that he submitted. Because the list that he submitted had his signature according to him. He also agreed with me that he kept a record of that list with his signature for his record. And therefore that the list that he submitted was not the list. I also put to him, and he agreed, that it is quite possible that anyone could have typed a list with those names and say that this is the list agreed upon. He agreed. And I believe we stopped somewhere there to continue. So I believe that the case is going well. And importantly, he said that he couldn't remember certain things. And, the things are on tape. And when I reminded him that the things are on tape, he suddenly kept getting back his memory. Once you remind him that it's on tape and the tape is already with the court. So I think the evidence is unfolding well. And we are to resume on the 9th of December all day for continuation.
Are you privy to any information about the actual list being submitted to the court? Because Mr. Ford just said that the actual list, even though the one that you referenced does not have the signatures, they went on to submit the actual list to the court.
No, Mr. Ford cannot say that. I borrowed the court's copy of the list. It is Mr. Remember I asked him, I said that this is the list that you tendered. It is his tendered list I used. I didn't use any other list. The list could have only come from him. He put in the list. I have a copy of what he served me. The court has a copy of what he filed with the court. So if they are now saying that the court has a different list and some other list, completely wrong. The court cannot have another list. That is Jones' list. He is the one who brought the list. So how can the court have a different list, or he has a different list? Unless they serve me with a wrong copy of documents. But in any event, I didn't use my list. I asked the court to borrow the court's file. And I used the list that is in the court's exhibit, tendered by Mr. Ramjatan and attached to Mr. Jones's affidavit. So that's a very, very strange argument if they're coming with that now.
All right. Thank you.
You're welcome.
Thank you.